Hi everyone, it's Jim Filippi from the Filippi Law Firm. Today we're going to discuss wills and everything to do with wills, give you some examples and break down each individual type of will. I think you'll find it really incredible, and I thank you guys for watching. So we're going to start off with your very basic last will and testament. The cool thing about this is it could take a few different forms. It could send assets to a trust, or it can, on its own, distribute your own property. But let's talk about how a will is formed. First, the person making a will has to have the capacity to make a will, meaning that they don't have to have full faculties. They can be suffering from some sort of mental deficiency, but they just have to understand what they are doing, how are they disposing their property, who's part of their natural part of their family, and that nobody is forcing them or unduly influencing them into getting a will. Then we have to look at what it is they're giving away. They can only give away items in their estate that they actually own. So it's important to understand exactly what kind of assets are in your estate. And it gets a little difficult when you're dealing with community property interest in states like California. Now you'll understand that wills themselves have been around for many centuries, and so therefore you'll see that wills will take different forms in a lot of different states. In the United States, for instance, most states recognize validly formed wills created in other states. So they're usually transferable, but I always suggest talking to an attorney in the state that you end up moving to ensure your current will is valid in that state. Another type of will is your living will. And if you're from a state outside of California, you probably heard this term quite a bit. This type of will isn't necessarily used to dispose of your assets. Instead, it's to take care of you during your life. Meaning that if something has happened to you where you've become incapacitated or ill, you're no longer able to make your own healthcare decisions, this living will step in, give someone authority to take care of those decisions for you when you cannot do so yourself. Now, here in California, we don't use the living will as the mechanism for allowing that to occur. We use a document called the Advanced Healthcare Directive, and it's basically the same thing as a living will from another state, but here in California, we just call it an Advanced Healthcare Directive, but it takes the same exact form, where it allows someone to step into your shoes and make healthcare decisions on your behalf when you're not allowed to do so. So an example when an advanced healthcare directive or a living will, if you're out of the state, would come in to operate for you on your behalf is if you get into, say, a car accident and you're in a coma and therefore obviously not conscious and able to make any decisions for yourself regarding your healthcare. The person you've previously designated in your advanced healthcare directive or in your last will, or in your living will, will be the one that steps in and makes those decisions on your behalf as if they were you, but with your instructions given to them prior through that advanced healthcare directive or living will. So obviously, having an advanced healthcare directive or a living will in place will benefit you in that you can make those decisions and designate a person before anything happens to you. And that makes it so that those that love you won't have to wonder what it was that you would rather have happen to you if you found yourself in a medical situation and not able to make your own decisions. It's very difficult to decide whether or not to pull the plug, let's say, if you're at the end of your life and there's no possibility of recovery. Making that end-of-life decision is very difficult for your family, and by having a living will in place or advanced healthcare in place, they won't have to make that decision for you because you've taken it off their shoulders. The con to having an advanced healthcare directive or a living will would be that if something were to happen to you or medical advances have occurred that could possibly have changed your decisions since making a living will or an advanced healthcare directive, it wouldn't necessarily afford you the opportunity to make those changes if something's obviously happened to you. So it's important that if you have established an advanced healthcare directive or a living will, that you revisit it quite often so that we make sure that it reflects your desires and how you want your healthcare to be managed. The next type of will we're going to discuss is a mutual will. Now, this isn't just one will, it's actually two wills, and they're typically created by a married couple who have also entered into some sort of agreement to make a will and to also make certain designations of assets to a particular person. So for instance, if you have a jet ski that you want to go to your son and have that go no matter what happens to you, you would enter into an agreement with your spouse and then enter into a mutual will, and so that if you die before them, that jet ski will still go to your son, even if your spouse would like to have it go to someone else. There's obviously a pro to this in that you can control the designation of an asset while you're still alive, and it'll control even after you die, which means that that jet ski is still going to go to your son even though you're dead. Now the con is the obvious, is that if you're the one that survives, you no longer have the ability to make a change to your will to have that jet ski go to someone else. The next type of will I'm going to discuss is a joint will. And you might notice on my face that I'm grim about this because I'm not a big fan of a joint will. It functions similarly to a mutual will that we just discussed, but it's contained in one document instead of two. And for those reasons, I don't think it's a very good option because it makes it difficult when one of the spouses dies and it has to go through the court process of probate, and then also has to go through probate again when the next spouse dies. It makes it very difficult for your family to administer that estate when they step in and divide up your assets as an executor. And so I always suggest using some of the other options that you have available instead of using a joint will. Now the next will we're going to discuss is called a holographic will. And it's a super fancy word of saying a handwritten will. And what the law requires is that the material portions of the will be created in your own handwriting. What material means is something that the courts determine when they look at your will because it's a case-by-case basis. So if you decide to go this route, it's always best to make the entire will in your handwriting so there's no question whether or not you've abided by the requirements of the law. Now, having a handwritten will means you've done it yourself, and it's probably not the best route to go because you may be making mistakes that you don't intend on making, and often the holographic wills are not going to be admitted to probate because of innocent mistakes that you have made in making your holographic will. So I always suggest that you have your will drafted by an attorney rather than handwriting it, so that none of those innocent mistakes will occur, and that in your last moments you don't have to worry about whether or not your assets are going to go to the people that you want them to go to. Now, a holographic will can be written on literally anything, including a bar napkin. If you have everything in your handwriting and it's got all of the requirements of the will, your will literally could be on a bar napkin. And the final type of will we're going to discuss is a noncooperative will, which again is another fancy lawyer term for a verbal will. Now you may ask yourself, how is it that a verbal will is enforceable? And I'll tell you, most times it is not. In fact, a noncooperative will is something from centuries ago and used throughout history by the military. They were also called battlefield wills when a soldier was injured and they made a certain gift to someone on the battlefield. Something like, my house to my best friend Bob. And that is heard by a certain number of people who would later testify that prior to his death, he made that gift to Bob. And so today's application of a non-cooperative will is very far and in between, and not an option that I would ever rely upon for dispersing my estate. And I never suggest that you do so either. I really hope you enjoyed joining us for this discussion about all the different types of wills, the pros and cons of each, and how they would fit into your particular estate plan. If you ever have any questions whatsoever when it comes to a will or your estate plan in general, I'm always available to your questions. Feel free to leave those in the comments section or contact us through our website at www.philippilaw.com. Thank you again, and I hope you have a great day.